Very kind of you to drastically our invitations to come to Brazil. We hope to keep our friendship for long years ahead of us. If you continue teaching, you will always be welcome in IBDT. Please consider it a second home. For everyone who hasn't come across Professor Jan de Goede before, he is one of the most experts in the world in international taxation, and he has been building a lot in terms of knowledge and contributions, especially with his work in the as a part of the tax authorities of the Netherlands back in the past, a few years ago, and also more recently as a member of the Committee of Experts in the United Nations. Jan de Goede knows everything about the changes and all the discussions in the design of the UN model, and we are very glad to present today one class on a topic that hasn't been taught anywhere else in the world. So this content that you will see here tonight, it's brand new. It's absolutely new. The proposal to amend the Article 12 of the UN model is something that was proposed very recently. So we are very happy to have the opportunity to hear all the details of that proposal, and the topic is very important for Brazil, because we also I can say that Brazil is part of the countries that sort of propose this amendment indirectly, let's say, with our practice to impose taxation on software licenses, even software license for the use of for the user, right? Not for someone who will subsequently resell that. So let's understand how it goes. And for those of you who are watching us virtually, please feel free to present questions at any time. Raise your hand. We have sufficient time when we do love when people make questions. So feel free to do that. I will be following the questions here, and I will interrupt Jan when it comes. Thank you very much, Jan, once again.
Thank you very much, Victor. It's a great pleasure to be here. As I mentioned already to the students, I have a long history with Brazil, because actually at the final stage of my economics and law study, more than 40 years ago, I had a project in Sudene that we as students had to evaluate whether or not that was attractive to make an investment there for one of our large multinationals. And unfortunately, they didn't take the effort to translate everything. So I started to read Portuguese. And what you just said, I could understand word for word, but I cannot speak. And sometimes it's also advantageous because it would sound very clumsy if I would. So it's a great pleasure to be here, and it's a challenge for an old person like me, relatively old, to talk about a modern development as taxation of software. And we are in a business which is very dynamic, because actually I sent the text of the PowerPoint a month ago or something like that, and it's already outdated because it's no longer a proposal. About 2 weeks ago, the UN Tax Committee in Geneva, I was there, accepted a change to the UN model, including a source taxing right for payments on software. Yet, I also don't mind that the text is still like that, because what I try to do is walk you through the history. So what is behind it? What are the issues? What are the questions? And I wrote a rather critical article about this idea. And I must say, looking at the final result, a number of those questions, particularly important for applying this kind of provisions in practice, are still valid comments. So this is a bit the program of today, which is quite demanding, not only for you, but also for me, because we have to run through a lot of more or less technical matters. So I will say a few words about historical overview of the interpretation of these provisions in both the OECD and the UN model. I will mention an important Supreme Court case of India. Just before finalizing the PowerPoint, I added a number of additional international case law examples in this area. I will talk about this proposal, the first proposal, which was rejected, and a number of subsequent developments. I'll give some general and technical comments on it. And we'll end up with some latest developments. Good. So that's part one, the historical overview of computer software, how it's treated in the OECD model. You see the depiction of the OECD model, and that other impressive building is where the Supreme Court of India is. Problem stated. So when you start to study something, the first thing is there a problem? If so, what is the problem?
Okay, hold on a second. I think we're not sharing the screen.
Okay, well, it's good because we are just starting with the problem.
Right.
So nobody missed something except a nice picture of the Indian Supreme Court.
Now you all can see here. And yes.
Yeah. That's another aspect of software. Huh? If it operates well and IT, it's a blessing. If it fails on you, you're getting completely lost nowadays. So first of all, the problem stated. Why is there a problem? Because over time, when the use of software increased, particularly in the case of cross-border payments for that, the question arose, are payments for the use of software covered by Article 12 on royalties or by the business profits article? And you know, that is a big difference, whether it's the one or the other. It doesn't go, maybe I should use this one. No. Yeah. If considered royalties, you know, under the OECD model, there is an exclusive taxing right in the resident state, no taxing right in the source state. However, if that was really the opinion of all the OECD countries in 1963, there would not have been an Article 12. because without Article 12, there would only be exclusive taxation in the resident state if the provider of the software has no PE. So basically, Article 12 is redundant from a true, sharp OECD perspective. But because already in 63, the OECD countries didn't all agree, they put in this article with exclusive source taxing right, which allowed it to be easily amended to include a source taxing right like we have for dividends and interest. So that is interesting to realize. Now, if considered as a business profit, as I already mentioned, there would still be exclusive taxing right in the country of residence unless the software was made available through a permanent establishment in the other state. There is another major difference. If it is qualified as a royalty, there is a taxation on the gross amount of the payment. If it is actually provided through a permanent establishment in the other state, there is no limitation to taxing that, but then they have to tax the net income. So there is a difference there too. Okay, so the first thing, we know there is a problem. Is it Article 12? Is it Article 5 and 7? The next one is, what is software? How do we define software? And simple-minded people like I am, who is only very diligent, but not extraordinarily clever, they have to systematically analyze, also when I was a legislator. So never immediately dive into all kind of details, just get the main picture first. And the main picture is that there is a definition of software, and software is a program or a series of programs containing instructions, not for me or my wife, but for computers. And we distinguish two types of software. The one that make a computer run, that's called operational software, and software which enables the computer to carry out specific other tasks. That is called applied software. Nobody uses that word anymore, applied software. We speak about apps. I still remember when I had my phone, the mobile phone, that someone asked me, do you already have many apps? I said, are you crazy? I have a telephone to make telephone calls. I don't need any apps. If you now look at my telephone, it bursts out of each other because of the number of all kind of apps. And it's almost unthinkable not to have such apps. Now, what is also interesting, software can be transferred in all kinds of ways. It can be transferred via a disk, like in the past, a tangible carrier, but it can also, of course, be transferred online or can be downloaded, etc. Another interesting part is that you have both cases where software is integrated in something else, like certain kind of hardware, like in a machine or in a car or in an airplane, and you have software which is delivered separately as a separate product. Now, what is important when you analyze something like this is, where is the intellectual property in software? And the OECD, when they developed their interpretation, they looked at both the IP legislation, intellectual property legislation, and the tax legislation of a lot of countries. And there it turned out that what is protected in most countries under copyright law is not software as such, but the program which is included in the software. So basically, in the approach of most countries, the software is only a carrier of a content which is protected under intellectual property law. And if it is protected under intellectual property law, it's usually as a copyrighted work, a work of either literary, artistic, or scientific work. So, and in this copyright, there is a distinction between the copyright in the program and a copy which contains the copyrighted element. And that last part is actually a product. So the copyright within the software is the thing which is actually protected in most countries under copyright law, but you can equally sell the software which has a copyrighted element in it. So that's what we call copyright in the program and software which includes that element. And that is important for the distinctions which are later made when it comes to the interpretation of these matters. Because, you know, if you buy a computer and you buy additional software to work on it, you open the software and the first thing you see is a copyright claim. So you do get the right to use the software, but you have a very limited right. You can only use it for your own purpose. You are not allowed to duplicate and sell to someone else. You are not allowed to modify. It is a copyrighted content. And what you acquire is only the right to use it for your personal capacity, for your personal needs, which is different from the case that you acquire the copyright in the software. So when you get a license that you may use the copyright in the program to multiply, to distribute, to sell, to amend, to adopt. These are two different things according to that analysis. So what do we know so far? First, there is a problem. Second, we have a bit of an idea what software is. And the third one is, how does that relate to Article 12 of royalty article? And what is the definition of royalties? Payments of any kind received as a consideration for the use or the right to use a copyright of literary, artistic, scientific work, but it's going much broader than copyright, payments for the use of patents, trademarks, etc. For our purposes, it's important that this wording is identical in the OECD model and in the UN model convention. Now, when we look into the history of Article 12, and I had the benefit of consulting publications of IBFD, where other scholars had done also that kind of historic research. When you look at that research and you look at the history of the OECD model 1963, you can conclude that the words, the use or right to use, were intended to cover payments for the letting, the hiring out or use of certain intangible property, like intellectual property rights, but also, for instance, know-how, which is not protected under copyright law. And similarly, a taxing right with respect to the use or the right to use tangible property, like machines and equipment. And in those cases, there is an exclusive taxing right to the state of residence, and the inclusion of an article, as I mentioned, not necessary if you would really like to have an exclusive taxation, because then Article 5 and 7 would do. And as I already mentioned, the wording which was introduced in the OECD model actually already reflects that not all the OECD member states had the same view. And to accommodate the ones that were in favor of a broader application of source taxing right, they formulated Article 12, which can be easily changed to introduce a source taxing right. So far, so good, a bit about the history. So what happened is increasingly with the use of software, there came questions about all kind of situation. And that's what happens in practice. People throw everything in one basket and everything is being confused and everything is put together. The use of something, the sale of something, distribution rights, etc. So in 1992, the OECD created what we call an autonomous interpretation of the notion of royalty. That is an important term because terms which are not defined in a treaty are allowed to be interpreted according to Article 3, Paragraph 2, in line with the domestic law. The disadvantage of that is that if different domestic laws exist, there is no same treatment in the two countries, and you have the risk of double taxation. So although the word payments, for the copyright, etc., are not further defined in the OECD model, the OECD decided to give an autonomous interpretation, which means you cannot follow your domestic law, you must follow that autonomous interpretation, which is included in the commentaries of the model. And what did they do then? They really analyzed the whole stuff. They consulted IT experts, they consulted IT companies, etc. And they distinguished 6 categories of payments. And the ones were for the transfer of the full ownership of the intellectual property. That's what we call a sale of, not a right to use, but a sale of the intangible itself. Then there is a complicated second category of a part sale, where you sell only part of the proprietary rights in the intellectual property. That's category 2. Category 3 is the use of the rights in such a way that you would violate IP law if you didn't have a license to use it like that. That's very complicated wording, but it simply means in the third category, you have the right to exploit the copyright itself, which is in the software. That is category 3. Category 4 is where you are having a right to use the software, but only for your personal use and no right to exploit the copyright in the software yourself. So that is a limited right. Like I already gave as an example, if you buy a computer with software in it, the first thing you see when you start to use it is a big copyright thing. Watch out, you don't have the copyright in this software. You are only allowed to use it. That is the 4th category. The 5th category is the acquisition of the right to make make copies for the operation within the same company. Because of course you don't need the software for one person in the company, you need a lot of that. But equally only for the limited use. And that is what they call in terms of this profession, a so-called site license. So basically category 5 is the same as category 4, but then for a larger group of users. Companies buy a site license to enable them to have 1,000 employees use that software, but only for the use of the company, not the entitlement to use the copyright in the software. The 6th category, which they identified, is the payments made for the right to distribute software. So like any other product, it is possible that someone wants to pay money for the right to distribute this product. And what we are talking about is purely the right to distribute, and the distributor getting that right is not allowed to use the software itself and has no entitlement to exploit the copyright in it. So the distributor is just a comparable distributor to the distributor of goods. And when a person pays someone else for the right to distribute, this is not a royalty. This is a business payment for the right to distribute a copyrighted article. So that is basically what the OECD, how they analyzed the 6 different situations, and they discussed that all in an update on the commentaries of the OECD model in 1992. And this wording was later also introduced as an interpretation in the UN model. So what we see is a distinction is made between the transfer of ownership rights, which is under the business profit article or the capital gain article, because you're selling the intellectual property right, the right to use the copyright in the software. So the program, which is protected under copyright law, you are allowed to exploit it, and the situation where you are allowed to use the software, but not exploit the program in it. And the last one is the distribution right. So in the analysis of the OECD, this is very fundamental to distinguish those categories. So what was the conclusion of this analysis? Not surprisingly, after what I mentioned, according to the interpretation of the OECD, the autonomous interpretation that the member states must follow, and the UN copied in the same approach, is that only the payments under category 3, which allow the person getting the license to exploit the copyright in the software, only those payments are categorized as royalties, and all the other ones as business profit, which means that if those activities are carried out by an enterprise of the other contracting state, the source state where the product is used and from where the payment is made, is only allowed to tax those other categories if it is provided through a permanent establishment in that other state. So the result of this interpretation is a rather restricted scope of when a payment for software can constitute a payment of royalties. As I mentioned, in the UN model, they discussed, and they copied exactly the same interpretation. In the OECD model, you know, we have observations and reservations made by member states, but also 35 non-member countries of the OECD expressed observation and reservation. You know, it's very important for practice in which countries they have different opinions on the interpretation via an observation, or whether they object to the text themselves in the form of a formal reservation. The UN model doesn't have that. The OECD has only 38 member countries, reasonably developed country, so they express always their views. The UN has 195 member states, and many of them are not at all involved in these kind of discussions. So the UN model doesn't have specific observations and reservations, but it has minority dissenting views. And actually nowadays they are more sophisticated. They have small minority views and they have large minority views, but there's no mention of any names. So when they had copied in this interpretation developed by the OECD, there was a small minority of countries, and everybody knows whom, but you cannot read that in the UN model, that had the opinion that also the payments for these categories 4 and 5, where you only had the right to use the software, but not exploit the copyright, and even the payments for distribution could be considered as royalty payments. So that was a minority view. And it's not a secret that one of the countries promoting that view the most intensively, publicly, and eloquently was India. So the Indian representative, not officially representing his country in the UN Tax Committee, because those experts are only appointed in a personal capacity. They do not formally represent their country, but everybody knows that this was the policy of the Indian tax administration. Yeah.
Just a quick comment or question in terms of the definitions, because of course the category 3 is formulated in a broad manner, so it automatically overlaps with 4, 5, and 6, right? So if I understand well, category 3 could involve distribution rights, but in category 3, the company that has the right to exploit the copyright has the right to duplicate or reproduce the software, right? Mm-hmm. It's different from category 6, where you have distribution rights, but you don't have the capacity to replicate the software yourself. You have to always, so there's this thin line between 6 and 3, right? Both could be distribution rights, but distribution rights under 6 has less power on the content, cannot it's not authorized to distribute, right?
That's absolutely the case. I do think there is a bigger difference between 3, 4, and 5, because in 3 you really have the right to use and exploit the copyright in the program, and in 4 and 5 you are only allowed to use the software, but you have any right to exploit the copyright in the software. So there is a very big distinction in this categorization between 3 and 4 and 5. 6 is a special category. I agree with you there. And why is that the case? When you look into copyright law, it has several elements. It has the elements to exploit the right in the IP, and that has a number of sub-rights. And one of those sub-rights is the right to distribute. If you have the intellectual property, you also have the right to distribute it. Mm-hmm. But you also have the right to exploit it, to make it available to other people, to amend it, etc. In the case of distribution rights, you only have a right to distribute and no any other part of that intellectual property right. So there has been case law in India, and you are actually running a little bit ahead in what I'm going to say, is that this Indian view that also payments for distribution rights should be seen as the use and the exploitation of a copyright. There is a theoretical element of justification. However, Supreme Court in India has judged what is the meaning of copyright law. And there, when you look at those different elements, they consider distribution as a very subordinate kind of right, which as such is not the essential element of copyright. So the Indian Supreme Court said, this is so limited of the copyright that the right to distribute cannot be seen as the exploitation of the copyright in the program. So you are right, but because it is such a subordinate element of all what a normal intellectual property right contains, which is much more important than mere distribution, that the mere fact that you have a distribution right is judged by most courts as not being the use of the copyright in the program. So I try to be clear on how this methodology works. But this is the beginning of the trouble, because in practice, we will see all kind of things falling over each other. And it's the theory. If you don't have a theory, you get completely lost. You don't find your way anywhere because you're just jumping at everything. So we have a theoretical approach, which doesn't mean that we have solved all the problems in practice. Okay, so the UN commentary copied the OECD one, but with this minority view. Now, the Indian tax administration was litigating many cases, always taking the view that payments for the use of software was royalty, and that India was allowed under its treaties to tax a gross levy, to levy a gross taxation on those payments. However, and it's only about 2 years ago that the Indian Supreme Court, in the so-called Engineering Analysis Center case, judged the cases 4 and 6. So the case of using software without the right to exploit the copyright and distribution rights. And actually, it was a verdict, I think, of around 140 pages. So it was very well considered and discussed. And it was dealing in one move with more than 100 appeal cases. So that happens, huh? You have more than 100 cases of appeal to the Supreme Court, and they identified 2 similar problems: the character of a payment for the use of software without the right to exploit the intellectual property right, the copyright, and the distribution rights. And the Indian tax authorities, they did not only come with this idea that also category 4 and 5 should be treated as the use of a copyright, but they also said, listen, Supreme Court, there is a minority view in the UN commentaries, which recognizes there could be a different view, and India made explicit reservation in the OECD model as a non-member state that it did not agree with the fact of the analysis which was done, and that they took the view that also cases 4 and 5, actually, and 6 could be considered as royalty. Actually, the Supreme Court totally rejected those views of the Indian tax authority. They did a similar analysis of copyright law, etc., and they endorsed this distinction made by the OECD. So India tax revenue lost all these cases. They also said something, and that's very interesting in the general interpretation of tax treaties, about the value of these reservations made by the Indian government. And what they said, we are ignoring that reservation, which is very serious in some respects. But why do we ignore it? Because it is so general and vague. You may take the view that this is a royalty payment. This is not convincing to us. We do not give any value to that reservation made by India, number one. Number two, if India had this different interpretation, why did they keep using the same treaty wording of the models? So apparently the Indian government didn't have such a big problem with this interpretation that they kept using the same wording. So basically, this was a total defeat for the Indian tax administration. Now, I was a legislator in the Netherlands, and the tax inspectors all knew me, because if they had a problem, they would come to me and say, Jan, can you change the legislation? And then there is a Pavlov response of a legislator: change the legislation? Come on, try to litigate first in practice and see whether you can convince the judge. Do you know how difficult it is to change the law? I have more things to do. This is not on my priority list. So what we know is, if in the end the tax administration loses the case for the highest judge, either they accept their loss, which tax administrations sometimes have difficulty to do, or they try to change the rules. And that's what they did by supporting a discussion in the UN to explicitly include payments for software as being royalties. So having lost the legal case on the existing legislation, the existing wording of the tax treaties, they came with a proposal also in the UN Tax Committee to change the wording of the treaty, of the model. So, well, this is, you know, the Model Double Taxation Convention version 2021. And the other building, you know, is the headquarters of the UN in New York. You know, the tax committee meets once a year in New York and once a year in Geneva, which was the former headquarters of the League of Nations. So what happened in the year 2021, that's only 2 years ago, there was a meeting in the UN Tax Committee where a document was discussed to restructure and change the wording of Article 12 by adding a separate category of payments which would be considered as royalties. Article 12(3)(c). And almost literally, that provision said the following: payments of any kind as a consideration for the use or the right to use any computer software or the acquisition of a copy of computer software for the purpose of using it will constitute royalties. So whether you use the underlying intellectual property in the program or not. Why did they use this double wording? Because the software is in fact a copyrighted product, and you can either let the product like a leasing agreement, or if it is a copyrighted product, you can also sell a copy with a limited right to use. And to catch both situations, they added not only the words use or right to use any computer software, but also the payment for the acquisition of the copyrighted product in the case of using it yourself. Because if it would also be a contract entitling to use the copyright in the program, that is already covered at the beginning of Article 12, where it says payments for the use or the right to use the copyright. That is the category 3 in the explanation of the OECD model. In the next slide, I have put that text so that we can take a brief look at that a bit later. I just continue, huh? I think nobody will protest if we end early this evening instead of at 10:30. But we are not there yet, huh? There's still a lot of misery to come. This is only to give you the main ideas about what's going on. So what happened? This proposal was discussed in the UN Tax Committee, and it was clear that that approach also met a lot of resistance. Principle-based resistance of countries that just don't want that because they are opposed to expanding source taxing right on gross income, but also, as we will soon see, very many difficult interpretation problems and application of this in practice. So when there was a vote in the UN Tax Committee, which hardly happens, but this proposal to change the model was rejected. So don't forget what we are talking now about later is what this proposal was with all the pluses and minuses, but don't forget that proposal was rejected in 2021. So the UN model 2021 was not changed in according with this. However, what they did do, and if you take the trouble of looking into the commentary on Article 12 of the 2021 model, you see that they have enormously expanded the minority view to make much more clear what this was based on. Like in the case of the distribution, saying that there are countries that take the view that also payments for distribution right should be seen as a use of the copyright and should be taxable. And also the mere use without the right to exploit the copyright. The reasoning being that the mere use is in fact the leasing of the user, the use of the software, which compared to the origin of this provision, which I have discussed with you back to 1963, could be interpreted perhaps in a much broader sense. So these arguments of a minority view, which were not followed and were rejected, they are included in the current commentary of the existing 2021 UN Model Convention. What they also did, and that's what really irritated me a little bit as well, I must say, is that they did not only give that minority view, which is completely understandable, that's how the UN works, there's majority and minority, but what they said in a few lines, if you don't like this interpretation, you can add that wording, which you see in red. Then you can amend your treaty and put that wording in. Now, what is my problem with that approach? Currently now in the UN model commentary, you see a minority view and you see this text, but there is no commentary in it on this text. So countries that think, oh yeah, I want to do that, and they just blindly copy that in a treaty with a country which takes the same views, they've copied something in, and when it comes to interpreting that wording, there is nothing, because the commentary only has that text option without explaining the pros and cons and how to interpret. So that is just one of the elements which in the article I have written on these matters that I have dealt with. Okay, is it reasonably clear so far? I am trying to tell it as a very simple story. That's the teacher. The worst teachers are those who want to pretend they are very learned. Those people you should always mistrust. The true academic is able to explain something difficult in reasonably simple words. If someone tries to explain something very complicated way, it's usually an indication that the person doesn't understand it himself or herself. Let's treat men and women equal in this respect. Men can be deficient, but women equally. Huh?
Yeah, I would also like to add, for everyone here in the audience and also watching us from their homes, feel free to pose any question, even if it sounds stupid, because, questions that sound stupid are normally the best questions, because as Jan was saying, something might be wrong either in the wording or in the explanations. Like I think this red sentence looks like very wordy, right? Contains many words.
Yeah.
There should be like 10 other easier ways of saying what they want to say. It's a very lengthy way of defining use of software. And also I would like to share with everyone that this topic is tough for all of us. Like I feel like I don't know anything about IP law, property or copyright law. When I see all these different explanations, and even Jan, who is a very expert in this kind of topic, he has to do his preparation to be here. It's tough for everyone, so don't feel ashamed of posing even the very simplest questions. It's tough to set the borders between all these categories, right?
What happened to me was a disaster at some stage because I was participating in those discussions. Several people said, can't you write an article about that? So in my stupid ignorance, I said, oh yeah, I will write an article. Once you start to write an article, you're getting deeper and deeper into the troubles. And you think, why the hell can't I say no? Write the article yourself. So basically what you now see is a simplified way, but we are not there yet, huh? So there is trouble to come. But what I'm just trying to do after I had to study all these materials myself is what is really the philosophy which was used. And when you look at the commentary of the OECD model on Article 12, it's a mess. It mixes up those 6 cases in different places in that commentary. That commentary is very difficult to read. So I cannot agree more with you that even what now sounds to be simple is not simple at all. It's the result of spending a lot of time in trying to find out what's going on here.
Question.
Yeah.
Question.
Yes.
I don't know if I need the microphone or...
That would be better for the recording.
Yeah.
Hi, Professor. My name is Lucas. I had a question about, I don't know if this is going to be covered a little bit later, artificial intelligence. Essentially, when these discussions happened in 2021, I think we were still in the infancy a little bit of artificial intelligence as a product consumed by the mass market like we have today. And the question really is the dividing line between 3, 4, and 5, particularly, when you have a relationship like the one we have with OpenAI or ChatGPT Plus, in which you can pay a $20 monthly fee to access that database and have some sort of, now I'm borrowing Microsoft's wording, copilot, the copilot that will help you figure out your way through that data. That's one way of using it, but you can also use it to build your own business and create code and have what recently, I think yesterday or a couple of days ago, they showed the creation of a ChatGPT chatbot that can be customized for your own needs. So then it kind of gets into a little bit the category 3, because I'm not just purchasing a license to use it myself. I'm actually using the code within ChatGPT or within OpenAI to build things for myself and to build things for my business, which traditionally would be the kind of thing that you would pay sort of for the source code of a software or something like that. So how do we apply, or is there a way for us to apply Article 12 as we have it today to these sorts of payments for artificial intelligence?
Actually, I must tell you that I am an optimist by nature, and I did not make that myself. It's in my genes. My father was like that. So even if I think something will never be solved and will be difficult, I am absolutely sure that there will be interpretations about that. But what you are basically saying, and we will talk about elements of that in less recent developments than the artificial intelligence, which actually is developing today. Tomorrow, there may be things possible which are not possible today. So what I would say is, so far, I have hardly ever seen in more than 40 years of career, something really new. Basically, it's always putting elements together, like in any form of science. But if you analyze everything very specifically, you find out what the elements are. And if you look at what you just mentioned as a couple of words, I am allowed to use a kind of code. Now, sharing a code may be sharing know-how, which is not the same as having an intellectual property right to something. So what in the end tax lawyers have to do is look at a contract, spend days on analyzing the contract, put all kinds of questions. What is exactly in that contract? And then you can disentangle elements. Maybe you have to take apart a payment or a thing, and you identify different elements. And that's exactly what we are also going to see in something called embedded software. When you don't only have a right to use a software, but when you are buying something which both has the normal traditional physical hardware, something like that, but also contains software. And then you have to disentangle. And that is where a huge problem starts, because who has to do that disentanglement? Who will make that interpretation? The OECD in 1992 developed this methodology. One of my problems and one of my comments on quickly accepting this red wording was exactly, if we now do that, and we know there is all kind of different applications, there is software as a service, there is infrastructure as a service, and what comes closer to what you were saying is platform as a service. And nothing is said in this whole methodology and in this discussion about disentangling those elements. What you do see at some stage is tax. And now I'm going to say something, this is to go into one ear and into the other one. Tax is maybe not a science. Tax is something very practical. I'm an economist. Tax is levied to fund the financial needs of the state. And because we have made it very complicated, it becomes a technical, scientific element to still try to make something out of all these complexities. But basically, tax has only one purpose. That is to raise funds for the state in a most clear, equal, and simple way to implement. If it's not complying with those basic principles of levying tax anymore, we are creating a monstrous thing, which is only beneficial for some categories of people. Again, I am friendly towards everybody, but that category of people are accountants, tax consultants, and tax inspectors. But you cannot say that when you develop legislation like that, and now the legislator speaks again, that you are doing a favor to taxpayers. Because in the end, I am a taxpayer as well. In the end, I don't care whether I have to pay the tax inspector what they call tax, or that they make things so complicated that I have to pay the same amount to a tax advisor. I don't care. We have an expression in Dutch that says, it's equally bad whether you are bitten by a dog or by a cat. So it's a long answer, but I hope I have some elements in it. We will go onward with it. And you are tempting me like always people do with questions, to go to a different path. And that is about artificial intelligence. How useful is it? How reliable is it? And I am not using it. Why not? Because currently I don't need it. And I'm a Dutch person. So I'm not going to spend any dime on anything which I don't yet have the feeling I really need. But I am curious enough. So with someone else, I put two questions to AI. The first one, give me an analysis in one page in English, because you can also say in Portuguese, etc., of the main differences between valuation problems in customs law and in transfer pricing. That's a very technical question. I got an answer. I was completely astonished. Excellent. As far as I could check, I didn't see anything strange. But then the second question, because I'm a devious type, I put the question to AI, how is it possible that Mr. X, resident of my tiny village in the Netherlands, how is it possible that he became king of the Netherlands? Mm-hmm. And I got one page again, incredible story. And you would absolutely believe it if you didn't know it was not true at all. It was complete nonsense, but put together in a very systematic way. So the only reason why I make this small side path is that artificial intelligence is an enormous blessing, like the whole development of software, etc. But we must be very careful with how we use these things. And when it comes to payments for it, it's also important to know who is paying for what entitlements do you get? When we look at the whole business model of the Googles and all these other ones, it's a two-sided market model. You get it as a customer, you think you get it for free, but basically it's developed on the basis of your data, which are put into the system. So who should earn what? Now, when it comes to legal terms, and we have to analyze according to legal terms, we have to, in the end, look at who owns, in the end, that intellectual property. And if you own it, and that is recognized and protected, then there is a specific nature to the payments you get for it. But if you are so crazy, I'm exaggerating, of course, so crazy to give all your private data to a third party who can make money out of it, and basically what you only get is the right to put some questions or things in that system, but you don't get any ownership right or remuneration for those data, then basically you only have the right to use that, but you don't have an ownership right which you can sell to someone else. So that is a very long answer, but showing how complicated and how diverse this whole world is. So if you can, like we have now seen with software, if you can exactly define what you mean by artificial intelligence and what exactly are the key features of these various types of use of it, then people can start to analyze the tax consequences. But before that, maybe you can ask AI what it thinks of it, and that might be very interesting. But it might be the same story as how this simple guy from my village became king of the Netherlands. Okay, I'm sorry if
I think we can take advantage of Lucas's presence here to come back to that question later, because Jan will bring more details that will raise the level of the trouble, as you mentioned earlier.
Definitely. But I wanted to give a kind of bonus to the first one who was putting a question. I am like that, you know? Everything is generally considered, what I do. It's very unpleasant for my wife. Huh? To have a person like that, she's always happy when I go abroad. Huh? She brings me to the airport to be sure I'm gone. But after a few days or a week, she starts thinking it's a little bit boring in the house. Okay, we continue and we will partly address the kind of things we're mentioning. Okay, so this is this new proposed text, and we take a brief look at that because they use this opportunity to structure it a bit more readable way, because now it's all text one after the other. It was. And now they have disentangled the various categories. And why did they do that? And that's exactly also one of my problems with this approach, because they said in practice, there are different rates in tax treaties for these different kind of categories. And I did that myself. When I could not agree with another country to a very low withholding on royalties, we were introducing what we called the Christmas tree, which means several balls in the provision, that there would be a higher withholding tax on copyright use, and there would, for instance, be a lower withholding right on patents, because patents, like devising certain new engines and things like that, or new medication, is sometimes much more costly. So the net margin on those kind of things is many times different from the author right of Hillary Clinton, who wrote a book about her husband. Maybe they gave her $1 million, maybe $5 million, but that is nothing compared to the development of a new medicine, which may cost billions of dollars. Huh? So they disentangle that, but that is understandable. But when you then subsequently treat categories and you can have doubts as to under which category it is, and you have different rates, I don't have to explain to you, there will be a lot of tax planning and presentation of facts and circumstances to be under the lowest rate. So disentangling here is very nice. It looks very readable, but it can also be the guidebook for tax planning if you have different rates. Now, what you see here is that the right to use the copyright in the software is still covered by the same wording, which you see in red on top, a payment for the use or the right to use a copyright. That is category 3, which is still there. But now you see at the bottom part C added, and that says that you are having royalty payments in any case where you pay for the use of software. So even if you don't have the right to exploit the copyright in that software. And as we will soon see, this whole setup also leads to particular questions and particular issues. Is that text a little bit clearer, what they did? So this proposal, which was rejected in 2021, was meant to include the payments for the own use, so the categories 4 and 5. And that's why it's such a long formulation, because leasing is normally expressed as the use or the right to use, but because in this case it is a copyrighted product, you can also buy it as a product. So if you would only use the words use or right to use, you would only cover legally formulated lease agreements, but not a sale with limited rights. That's why that wording became so long to catch both situations. What is interesting is that apparently the people driving this change, and I mean the Indian tax authorities, which are also represented not officially, but in the UN Tax Committee, they pushed for this idea, but they did not include the distribution. Because also, I guess, their Supreme Court views that distribution right is only a very subordinate element of the use of copyright. So they let go of the idea that payments for pure distribution rights are also to be considered a royalty. They let go of that. Now, just one other remark, which I basically already made a little bit. It's increasingly customary to deliver copies, not by physical means. You don't put them anymore on a diskette which you hand over, but you can download it or do it remotely. And that means that the form of making it available should, in principle, not drive the characterization. But also there, we will see examples where the form nonetheless raises substantial questions, because under the legislation of some countries, some forms of making it available might meet a copyright definition. We will see that shortly too. So one of the things which strikes when you remember a little bit that old text, when you now get the right to use software, including the right not just to use it yourself, but including the right to exploit it within one provision, that falls under two categories. That falls both under category in letter A, because the payment is also for the right to exploit, but it is also payment for the right to use. So basically, by that definition, we already have cases where you have both the right to use the software and the right to copyright, that if you have one payment, it can fall under two categories. And if those two categories have a different rate, good luck to you to try to disentangle it and to allocate the right amount to the right thing. That is one example where even within the provision you can have a problem. Now I come back to things which I don't understand at all, secret codes and things like that. There are also contracts where you only get the right to use software, but where you do get some additional information about certain source codes in circumstance where those codes are not protected by intellectual property right. Then we have again two categorization within the same provision, because we have then under letter C a payment for the use of software, but making available that code, which is not copyrighted itself, we have a name for payments of that kind too. That is called know-how. When it is undisclosed knowledge, which is not under intellectual property law, but which is not publicly available to everybody, you have to pay for it. That's what we call payment for know-how. So in that example, which I give, you also have a payment which has two elements. One, the making available of know-how by giving information about this code, and the other one, the payment for the use of the software. And again, if you have different rates for those payments, you have to try either to disentangle or to say it has one character. That is only within that same provision. Some examples. So what you have as well, and we will come back to that later, you also have cases where there are payments for things where you could say, is this a royalty under one of all those categories? Or is it a payment for technical services, which is dealt with in the UN model in Article 12A? Or is it a payment for automated digital services, which is 12B? So we don't only have the problem that we can have multiple characterizations of a contract within Article 12, paragraph 3, but we can also have cases where we can have doubts about categorization between Article 12, 12A, and Article 12B, leaving aside that if it's in none of them, it can still be Article 5 and 7. So what I mentioned already is that this proposal was rejected, but that in the commentary, there was this minority view saying that categories 4, 5, and even distribution rights in 6, by some countries, might take the view that that is royalties as well. I mentioned that one. That has potentially an impact on litigation. That's why I keep saying that. The people who are in favor of that proposal, and this is a kind of repetition, but it's always good when you talk about complicated matters to repeat some elements. What is the philosophy in expanding this in Article 12.3 to the use? Because of this historic origin, that payments for the use or right to use of intellectual property, not only use and right to use of tangible property, were intended. If you look at the UN model, there is the use and the right to use patents, copyrights, etc., not the word software. And the UN model does have the payments for the use of the right to use of equipment, which the OECD has not. So the OECD is more restrictive also in regard to use or right to use of tangible property. Yes, please go ahead.
Yeah, if I may say something, I find it very amusing the way that the UN mentions the positions of minority views. And I was doubtful if you were going to say that, so let me say it for you. When you read the commentaries, the UN commentaries, it's hard to identify which countries made the point. And there's an interesting expression to refer to India, which I find sort of a paradox, because it says, in the view of a large minority, how come a minority can be large? But then Jan explained to me that India is a large country with a large population, so that's why when India or these countries with big populations pose a view, then they refer to large minority. I wonder how Brazil is referred in the commentaries, or how it will be referred. Anyway, and we might have a short break by 8:30. I want to say that because we will finish this slide.
I do want to mention one thing. The reason why it doesn't mention India, where it doesn't mention a country, is because it is only a committee, which is a non-governmental committee with experts in a personal capacity. And that has disadvantages in the sense that you cannot, and you are not allowed to identify. In the meeting in Geneva, some journalists who were there were several times seriously warned, because they had published reports in Tax Notes International referring to certain views as the view of China, India, whatever. And the UN said, one more time, and you will no longer be allowed to attend these meetings, because you are mixing up seriously two things: the official position of a government and the views taken by that expert. And the advantage of disentangling those is that we had discussions in the past where experts were contributing to have a technically sound wording, for instance, for 12A, while their governments are completely opposed to that provision. So if you would identify the experts with the countries, it would enormously limit the possibility to jointly agree about technical solutions. So it's not just a kind of being difficult, it is a legal distinction, but also a very practical one.
Yeah, and if I may say something from the Brazilian perspective, just to make a correlation here, as Jan is showing now the leasing of equipment, Brazil includes the sentence includes in the definition of royalties the leasing of equipment in nearly all treaties. So Brazil has a very clear position of expanding the royalties definition to also include the leasing of equipment. And since that is the Brazilian view, why not consider the right to use software as part of the definition of royalty per se? And it's interesting that the Indian persons who speak on their own capacity in the UN committee proposed a change in the wording of in the definition of royalties. But it makes sense because they lost the case, right? So they don't have any other option than to changing the law. But the same strategy doesn't apply to Brazil. And what the UN does when it changes the wording of the model is that it erodes the Brazilian argument in a way. When Article 12A and 12B, for instance, were included in the model, you remove part of the content that we used to put in Article 12, and now with this new wording, it will be easy for taxpayers to make the argument that this right to use software was never there before, and you should change your treaties in order to include that. So this is very intriguing to see how this will affect the discussions we have in Brazil.
But that's why I gave the history, because if you start to look really at the history, you see that the original intention was to cover any kind of use or right to use, a very broad category. And you were saying that Brazil, you were suggesting that Brazil was deviating, but Brazil has not been deviating in the oldest models, including the OECD model. Payments for leasing of equipment were covered by Article 12. So it's not Brazil that deviated from the origin, it's the OECD that at some stage said, if the only thing a lessor does is to make the stuff available, there should not be a taxing right in the source state. So basically what you could say is that the OECD views, in a way, narrowed down a number of source taxing rights. Now, what about the position of Brazil? And I'm a very nasty person, huh? So if I get challenged, I give you a different answer. So my question is, what is the position of Brazil if it wants to become a member of the OECD? I heard professors from Brazil stating that your transfer pricing system was the best in the world and the whole world had to change to the Brazilian system. Brazil, apparently for economic and other reasons, wants to become a member of the OECD. And now the legislation is there to abandon the Brazilian transfer pricing system and to go to the OECD one. So whether a country is big or small, even a big country can get into economic trouble, and then they look for ways to improve the economy. And if they have the feeling that there is a better chance of improving the economy by being closer to the OECD, it also means that maybe they have to abandon some of their views. So I would be very cautious to say that the approach of Brazil is the future one for Brazil. And I think the economic strength of India compared to Brazil is a different story. It's a different story. You see, the two major upcoming powers that made the most innovative developments are only China and India. If you look at the other members of the BRICS, Brazil, South Africa, and Russia, actually they kept earning their money in the same traditional ways by exploiting natural resources, etc. But neither Brazil nor Russia nor South Africa are in the top of developing the new economy. So it's a very complicated story. And I'm a Dutchman, so you can expect from me that I speak my mind and that I am not afraid if I stand on someone's toes because someone steps on mine as well. So I think if we do that, we can do that. But I think we should look at the economic realities. If Brazil were convinced that transfer pricing, their system was the best in the world, and also software, they are the best, etc., why would they want to become member of an organization which clearly has different economic philosophy? And putting an end to that because we need a break, I'm an economist. Having high withholding taxes, is that beneficial for developing your economy? Or is it an easy tool to get short-term revenue? Because it's easier to have a gross withholding tax on that payment, which is easier to administer, than a more refined system of taxing net profits. So as an economist, I don't have any objection for funding of states of withholding taxes. But if they are really high withholding taxes and they exceed the net margin that enterprises make on that, what do? Either they don't give you that IP anymore because they don't make enough money on it, or they make it much more expensive for you. And that means that your economy, when they want to have the use of the latest technology, has to pay much more for that than another country with a low withholding tax. So in fact, economically, it's a very complicated story. And if you then say, do you say that all withholding taxes should be abolished? No. Yes, in some cases, in the European Union, we abolished all of them. The Parent Subsidiary Directive, 0 rate. Interest and royalty, 0 rate. Economic models show that that is the way to boost your economy. Economic growth has been measured. But is that same recipe a good recipe for a developing country, which cannot maybe apply very sophisticated legislation? No, then you still have to earn money for the state to invest in innovation and things like that. So I am taking a kind of middle position, like also in the discussions in the UN, that I support if developing countries really need this kind of levy, because otherwise they can't get their funding and their domestic resource mobilization. But if you try to get me on board to say there should be 30% withholding taxes on these matters, then I'm saying, oh, wait a minute, what are you doing? Shall we have a break? Sure. Yeah.
We're going to have a short 10-15-minute break for those who are watching us from home. Please do so as well.
So.
Você interrompe a gravação? Recording.
Thank you. Of course, I thank you very much because it gives me the opportunity to go way beyond the discussion. And I'm saying things that other people might not say. I am very open how these things are being considered.
Yeah. Lucas.
Professor, good to see you.
You're working on a tech company.
I am working in a tech
I
company.
already had that suspicion.
Yeah.
I have a question.
Yeah.
But it's just
I'm a hybrid. I'm a tech guy as well as an academic guy.
What do you actually venture? Okay, ladies and gentlemen, we are continuing. So what I was explaining is the draft commentary with the proposal to change the UN model, which was rejected. And the reason to discuss that draft commentary is because that is where you could also see the different views. And very recently, there were 2 new documents, and we will speak about those later. So what I mentioned already now a few times is the reasoning for people to want to tax software payments, even if there is no entitlement to exploit the copyright in it, is the analogy with leasing out matters, either leasing out equipment or leasing out intellectual property. And the reasoning is that even if you are not allowed to exploit the copyright in the software, you do get a right to use the software. You are using the software in your business. So those who are in favor to include the use of software, even if it does not have the right to exploit the copyright in it, is because they say making available that software, including that secret formula, etc., which is copyright protected, is in fact the same as leasing it. You can in fact not use that technology, which is embedded in the software, if you were not allowed to rent it, to put it that way. So that is the reasoning, which goes beyond distinguishing between the use in your own company and the exploitation of the copyright in the software. So that is what the proponents say. And as I mentioned, in principle, they take the same view with payments for distribution rights, because a right to distribute is a part, a minor part, subordinate part of the intellectual property right of copyright. It has several elements. You can multiply, you can sell to others, but you have also the right to distribute. Now, what is the opposing view, which in fact supports this OECD approach, which, by the way, is no longer just something from the OECD, because the UN up to now also endorsed that. And as I told you, even a Supreme Court of India followed that same distinction. So what are the people putting forward and the countries that are opposed to having royalty character of any payment for software? That is that they generally say having taxation on the gross income is not a good system, because having a percentage of the gross income may exceed the net income which the recipient has from it, because you are not just getting gross income, which is the same as net. No, you had to make all kind of cost to develop the IP. So to avoid obstacles and double taxation, you should not strive to have gross taxation on this kind of payment. And they stick to the idea that there should not be such taxation on the gross amount. There should only be taxation on the net amount, which under the current treaties is only allowed if you have a permanent establishment through which you provide that service. So that is one of the problems which they have. Another one I personally raised is a theoretical but very valid argument as such. Is there any difference between the use or the sale of a copy of software in which there is included a copyrighted element, or the renting out or buying of a book? There is no difference, theoretically, because also the content of a book is protected by copyright. So why are we talking about a rule that redefines payments for software as royalties, whereas it is theoretically exactly the same as renting out a book or selling a copy of a book. Because if you buy a book, the same as if you buy a copy of software, you become the legal owner of that, but it has a limited user right. If you buy a book, you can read it, you can use the knowledge from the book for your own purposes, but you are not allowed to duplicate the content of the book and sell it to someone else. So theoretically, and I pointed out at that, I have a more academic theoretical problem with treating two things which are the same differently. And one of the reasons why I find that troublesome is that if you have situations of judgment, borderline difficult cases, and you don't have principle-based rules, you're getting lost. It becomes a mess because there is really no criterion at which you can measure it. So what I said, I am not crazy. I do understand that it's pushing for taxing rights on software. But if you deny the fact that that is the same as with books, and in my article, I gave other examples as well, you may have similar user rights. For instance, for products, which products could only be made by the use of a patent, otherwise you couldn't even make the product, then we do not give that label of royalties to it. So what I then said is, if you want to insist, and you keep insisting on this anomaly from a theoretical perspective, then please make clear that this is a very specific exception to a particular rule. If you don't do that, I already see the case law coming up of challenging the same thing in the case of books. That a source country says, okay, now books are sold to my country. Now I want to have a royalty because, like with software, there is a copyrighted content in the book. So it becomes actually a little bit messy. So I find that a valid theoretical argument against labeling payments for software generally as royalties. And of course, we have principles in the world, but we all know that business is done by striking deals. And deals are not always principle-based. But then at least make clear that this is a deal, which is not putting a standard for other cases which have not been discussed. So that is how I think about the analogy with other products in which, in fact, there is IP embedded without you having the right to exploit that IP inside that product. Now, the other problem they have is what I already briefly hinted at, that you have all kind of borderline cases. Is this within Article 12.3? Is it the first category? Is it know-how? Is it the payment for the software? And generally that within Article 12.3 is of no interest until you start to put different rates on the various elements. Because then suddenly that qualification within that provision becomes important because there is different levels of withholding tax on it. Leaving that aside, you have the discussion still whether something is really a payment for software or whether it is a payment for a service following under the regime of 12a, if you have 12a. If you don't have 12a, it's just 5 and 7, the PE rule, or under 12b. And there are, I'm running a little bit ahead because I don't know at what time we end and whether we can talk about all the slides or not. So I occasionally take something already for the future. If you cannot sufficiently clarify what is covered by what, then you may create a lot of trouble in the actual implementation of this provision. And one of the things we try to do, in which we are not very successful yet, but it is the topic of which I am a general reporter for the IFA Congress next year, is to try to manage and reduce the number of international tax disputes, because they are going up like that. And the judiciary can't cope with it, and the countries have difficulty in the map. So please, let's, when we take a decision, try to take into account the possible problems which this has in the implementation of the rules. If we don't, we are creating the huge flow of additional disputes and conflicts of the future right now. So these are a number of the problems. Then there is a specific feature as well in this UN provision, which was rejected, but the one accepted now has the same. It applies to any payment for software, which means that if my son, who is not a tax person, if he acquires the right to use software from a foreign provider, he will have to know these rules, and he will have to withhold tax on any single app he acquires. The treaty provision does not distinguish, contrary to Article 12a, it does not carve out payments made by individuals for their own use. Is that problem impossible to solve? No, you can solve it by making someone else responsible for the withholding. And that would be, who could do that? Banks, financial institutions. Why? Because they are dealing with the cross-border payment. So you can say to a bank, okay, you have to employ another 20 tax lawyers, because of course also the bank doesn't want to get into trouble by withholding the wrong percentage. Then they get fined and whatever, maybe even prosecuted. So they would then bear the burden of making all these distinctions. Another option, which I personally suggested, because I am not only criticizing, I'm always trying to also think about, if you really want that, how can you do it, is to follow the same approach as we know from VAT, from the digitalized economy. You don't put that burden on the banks, but you put it on the foreign provider. That provider, like in VAT, would be made responsible to withhold tax on the payment they receive and turn it over to the tax authorities of the source state. So again, theoretically, you can potentially solve it, but it is at least an additional complication to do it. Because if you don't do that, then you, as we say in Dutch, you count yourself rich as a state by saying, I can now have 10% withholding tax on any royalty payment. But if you cannot levy it from individuals, then maybe a large part of that revenue will disappear. So that is also a valid problem against the approach which was in this UN provision, which was rejected. And as you know, and I make you remember what I said before, the current commentaries 2021 and the model does not have this new wording. It does have this minority view, but it does give this text without anything about how to interpret it. So that is what I mean, one of the problems. If you put it in the commentary as a text option, so that countries think, oh, okay, the UN puts that in the commentary, so I guess this is a good thing. And when they start to apply it in practice, they get confronted with 100,000 problems and they have no guidance how to do it. So these were strong opposing views, why in the end, this proposal in 2021 was rejected. Yes, please.
This problem will not clarify in alternative provision. Apparently, it happens with any model. There is no model in
yes.
any model, because anytime that the model provides an alternative provision, it does not clarify how to interpret. It only gives the option of putting this provision in the treaty, but not clarify how to apply.
And
So
that's
it's a common problem, not
Yeah.
only with regards to software, but also other provisions in any treaty, in any provision.
we would have to look at each case, because I think there are also cases where there is a clear discussion why there is this alternative and what it intends to solve. In some, there is virtually nothing. In others, there is at least a beginning of understanding why it is. But my answer is also, is the fact that we are apparently not doing the right thing today an argument to keep doing it the wrong way? Whereas on the other hand, we say we want to reduce the number of conflicts. And you can only reduce the number of conflicts if you offer alternative approaches and text, including how you should interpret them. Otherwise, you are just throwing the problem over the fence. You just put it in, and okay, yeah, then we have another few thousand conflicts to come in the future. I find that a wrong policy. I do understand why it happens, because people want to finish the job. They want to push that view, and they don't want to be bothered with how it should be implemented. I want to score. I want to be able to say to my parliament, we have it. That it is unworkable is something which appears 10 years later when there is other people there. So that's what I mean. And that's, I think, the task of a person who tries to comment on it as objectively, maybe academically as possible, to also point at the possible risks of things. And not just to blindly say, we want more source taxing right, so we don't care what is said down as long as we have more source taxing right. I prefer a system where you have to negotiate, and sometimes you will get it, sometimes you will not get it, but that at least what you agree to is clear. And otherwise, we are just creating the problem of the future, which is nice as an employment project, if you look at it a bit cynical. So you should all follow this international master, you know, because we are creating your work for the future. So you don't need to be afraid there will not be work in international tax. The worst person is the one that really comes with simplification of tax law. That person will have many enemies. Good. Now, beside these arguments, which I have already discussed and looked at, there is this problem which I once mentioned already, but which is on the table as well. There is a limited number of cases where you only acquire the software separately as such, like in some of these very specific apps. But basically, we have a lot of other products and services which have a combination in one contract, embedded software. So we have various, in practice, we have various forms. So, for instance, when I buy a car, I buy the hardware, the wheels, the engine, the thing to steer, the mirrors, but I can perhaps also already buy the user right of all the software in it. So what did they say? When you see a big problem, you try to, you know, to say, oh, but it's not a new problem. Like you are saying, It's not a new problem that you put something as a text without proper commentary. Then there was the same response here. Oh, embedded software, that's not really a problem. We got something like that already and guidance. It's called mixed contracts. You have a contract which has more elements. And what is the theory of dealing with mixed contracts? You have to disentangle, even though you made one payment, you have to disentangle and treat each element of the payment according to its own rules. So if you would do that in the case of a car with embedded software, theoretically, if you buy and pay to a non-resident, you would have to distinguish the part of the payment which is for the good, for the tangible car, and the part which is for the use of the software which is embedded in it. And that one has a different regime under the tax treaties. The one, the capital gain, the other maybe Article 12. So you do understand we are now talking suddenly about a huge problem, because there are lots of products and services where you have both elements. So what is the traditional look? You must try to disentangle and treat each part, but we have a nice solution. If there is a predominant aim in the payment, a predominant purpose, you can qualify the whole payment under that category. So now I put you the question, if you buy a piece of machinery, which is a very simple kind of machinery, but with very sophisticated software, are you then basically mainly paying for getting the physical car, or are you paying basically for the sophisticated software to use it? Now that sounds as a stupid question, because we say, no, of course I buy a car because I want to be transported. So the main argument is clearly the car. But now I take the same with computers. You have a computer, which is a very down to earth, it's nothing. I mean, what is this? A bit of plastic and a bit of raw materials. But the real value is in the software, the operation of it. So if you have to say, what is my predominant part of buying this computer? Is that to get this hard stuff, or is it to get all the functionalities? So in practice, when you have mixed contracts, you may get into new kind of problems of what is the main purpose of buying that equipment. That's one problem. There's more. So I said maybe we end early today. That's because I am an optimist, because we're getting deeper and deeper into the questions. There is another phenomenon which we call enabling software. So what is enabling software? That is software, what the word says, which enables a real business transaction. And the enabling software is just provided by the person who wants to do the real business for free. So you don't pay for the enabling software. In the end, you pay for the real services. So you have to be aware that when you have a mixed payment and there is enabling software in it, that the price of the enabling software is zero. And examples of enabling software are, for instance, hotel reservation system. You are paying to that site to make a reservation of your hotel room. If you have to disentangle that, are you paying for the software which enables you to make that reservation? No, that is provided to you for free by the hotel platform. What you pay for is to rent that room. So when you have a contract like that, you must analyze whether there is enabling software. Another one is intermediation platforms, where you can sell this old clothes, which you don't want to have yourself anymore, but which may be very valuable as a second-hand beautiful dress for someone else. There are sites where you can sell that. You get software made available, but you are not paying for that software. You are paying for the dress. And the third one, and for me as an old guy, I learn all the time. If I keep doing this, I will keep learning until I close the coffin, you know, is usage track software. Who of you knows what usage track software is? Those who read my article, they know. IBFD. What is it? It is about the following kind of contracts. I buy a piece of equipment from the provider of an equipment. Okay, happy me, I got the equipment. However, that equipment needs to be maintained. So I have a separate contract, maybe with a third party, to maintain my equipment, to do the necessary maintenance. So how did that happen in the past? Then regularly such a person from the maintenance company had to come by and say, show me your equipment. I'm not talking about medical matters, so I don't make it personal. I'm just looking at him, but I am only meaning real equipment. So give me your equipment, I take a look. Oh, it's okay, I don't need to do. Oh, it's good that I passed by. I just need to make some changes. That is very costly because that service provider has to frequently come to you to take a look. So efficiency, use of modern technology, the service provider, the maintenance company, puts software in your equipment, and that software warns the service provider, now maintenance needs to be done. So it's very efficient. It can make the maintenance cheaper than under the traditional system where someone each time has to come and many times may come, whether there is no necessity. But that software you don't separately pay for as a client. It is only a tool for the service provider to be able to offer you the maintenance at an economic price. So meanwhile, you understand that we were talking about something that was a problem. Treaty qualification. Then we said, what are we talking about? We are talking about software. Now we know what software is. Now we look, how do you interpret? Then we have the OECD approach, developed after many years of research. Then we have the opposing views, which is different. Then we have possible article, which raises a number of questions. Then we have dissenting views on the same wording. And now, meanwhile, when trying to think about implementation, we have to discover all kinds of different situations. Is this within Article 12.3, letter A, letter B, letter C, if they have different rates? Is it 12, 12A, 12B? Is it a mixed contract? Can we cut it down in pieces or not? Is it free enabling software? Then you have no any payment for that respect. So in other words, applying that wording as such without sufficient guidance is not really that easy as it seems to be. Good. So I may put those two pictures in because the one on the left has the word broken. This is how some of you may feel after this discussion. My God, I am broken. Mentally, I cannot cope with this anymore. I thought we were going to talk about one simple thing, software. We all know what it is, and we end up with one big possibility of trouble. The other perspective is the optimist who says, okay, I see a new development, which also has many benefits. How shall we try to deal with this problem in a manageable way? And that means that being too greedy from one side or the other is the recipe for trouble. And that was all consideration why in 2021 there was a majority in the UN Tax Committee not to already support having that provision in the UN model. So my comments, I just give a few very quick ones because a number of them I have already taken on board. The first one, why do we have this discussion at all? Because there is a dissatisfaction between developed and developing countries of the current allocation between source country and resident country of taxing rights. And we have seen that. And what we should realize is that when we look at the UN is also pushing this feeling, more source taxing right, because of the SDGs. The SDGs, one of the major elements is to increase domestic resource mobilization. So a number of developing countries are expanding their taxing rights under domestic law, and then suddenly they see an obstacle in treaty application. So it is understandable that developing countries that feel the pressure to increase domestic resource mobilization want to change this balance of source taxing right and resident taxing rights. And we have seen this whole dissatisfaction, of course, culminate in the discussion on the taxation of the digitalized economy, where some developing countries think that this will be the big change, which will make up for all the money they have missed all the time. Well, that is a big misunderstanding. The digitalized economy does lead to the fact that you can earn money in a country without physical presence. So it correctly points at the fact that also the market has a value, but that doesn't mean that the value is equally not, or maybe even more in the resident country where they developed the whole digitalized economy at all. They took risks. They had losses in failed projects. So that is what we see, which is a kind of political drive in the UN, domestic resource mobilization, say to developing countries, you must raise more taxes, and then you see limitation in the treaties. So you can see this discussion of royalties maybe in a same perspective there, and we have seen the result of that in the adoption in the UN model of Articles 12A and 12B. Now, the ones that have objections, they object to gross taxation because of the risk of double taxation, that the tax on the gross is bigger than the tax which ought to be due on the net income. So that is a problem. But another point, and I have made that general comment as well, what are we doing now? We are hearing about an idea, and we know this is going to be complicated in a number of respects to implement. And surprisingly, in all these documents, you don't find any figure. You don't find any indication how important is this, how much additional revenue could developing countries generate with this, and what are the costs of generating it in the form of that you need more tax inspectors, that you need to have a whole system to collect the tax. So basically, it's a bit strange that very many business-like decisions, you have to make a budget. You have to say, this is my expected revenue, those are my costs, but we still decide on these matters purely on the basis of sentiments, not on the basis of real facts. And this is one of the things which I put into the discussion to say, should we just follow sentiments like that? Or should we at some stage need to try to find a balance between what is it worth to have this? How much additional revenue can you get? And how much does it cost to you? So that's a very generic thing. And when you look at the cost of implementation, you have to face all these kind of qualification problems and the possible disputes which may arise from it. So that raises the question, and I will be very quick about that because it's difficult to find a true solution, whether there should be not more focus on the fundamental solution of the resident source problem than to each time create new provisions which take a little bit of source taxation, but at the expense of a lot of complicated provision, which are also difficult to implement. So that raises the question whether the whole Pillar 1 project is apparently not meeting really the demands of all the players in the field. And if it does not, then whether you have Pillar 1 or not, which is totally doubtful still today, because even if the treaty, the multilateral Pillar 1 treaty is signed, there is one country which can avoid it ever coming into effect, and that's the US. Because you need 999 points to get it done, and only US companies are responsible for 486 points. So if the US doesn't join, everybody can sign. Brazil, the Netherlands, Germany, France, China, Malaysia, they can all sign, but it will never get into effect. A worse horror scenario is suppose this Democrat government of Biden is able to convince Congress, and at the next elections, the Republicans under Trump win, and Trump says, okay, after 2 years, I am terminating that treaty because it's not good for American business. Then for the whole world, this whole system is gone. So I don't criticize the efforts of Pillar 1. It's remarkable that they have been able to come that far in an attempt to remedy the problem of DSTs, uncoordinated levies, not covered by treaties. But for sure, it's not the ideal solution because Pillar 1 has some very specific vulnerabilities, except already its complexity. So some technical comments. So the elaboration of the minority views in this commentary, and I put that down, may perhaps lead to new litigation under the existing text. Because if you listened properly to what I was saying, the Indian Supreme Court did not pay attention to the Indian reservation because they considered them too vague. If they are now underpinned, like we have discussed, with theoretical arguments, why indeed you could take the view that payments for the use of software should be considered as royalties, then I am not sure anymore whether the Supreme Court would put aside this better motivated minority view. So that is interesting thing as such. Now, that puts another question on the table. If we do nothing, if we don't change anything, can we continue to work with the current wording and the current commentaries? And I put that element there too. There is also already a lot of unclarity in the current formulation of the commentaries when it comes to this point of treatment of software payments by interpretation, the autonomous interpretation. There are a lot of questions still about that, and it's messy in the commentaries. But also, this does not take into account, it was made in 1992, all these new kind of developments, and I don't even use that word AI, but we can use the words SaaS, IaaS, and PaaS, which are already much more advanced: software as a service, infrastructure as a service, platform as a service. I think we cannot just do nothing. We should try to get more clarity on the characterization of those kind of payments. And of course, that is related also to this idea of the bundled contracts, whether you can take them apart. So I mentioned the theoretical weakness of the current approach, that it only speaks about software, and it doesn't even spend one word on the analogy of exactly similar things like books, etc. So that I find a weakness in the current commentaries. And then, of course, there is this lack of legal certainty and administratability regarding these different types of classification, where I think more guidance would be needed to avoid future disputes.
Yeah, you allow me very quickly.
Yes,
So
of
this
course.
is the first slide where you mentioned SaaS.
Yeah.
And you said that before, but I just want to highlight, confirm with you. If I remember well, the UN commentaries in Article 12B make it perfectly clear that SaaS fall under Article 12B, right? Responsible for service, something like that. But it also, it's interesting, you know, the relationship among this article, because Article 12B applies subsidiarity in terms in comparison to 12. So 12 prevails over 12B.
Exactly.
I think that software is included in 12. We shouldn't apply 12B. The commentary the commentary only speaks about SAS and 12B, so it makes it also
Because currently in the model, payments for software are not covered by 12. So that's why they only mention in 12B. By the way, there are hardly any treaties in the world which have 12B. That's a different story. Because if you're a member of the inclusive framework, and in the end, 138 countries are, the inclusive framework members can say to a country that agrees to 12B, you are violating your commitments for Pillar 1. Because Pillar 1 has as a condition that you withdraw your DSTs. And basically, when 12B was discussed, I was in favor of 12B. At the time, Trump was still governing. Because when Trump was still governing, the US were not prepared in any way to think about Pillar 1-like developments. And then I said, if there is no scope for a more general, let's call it Pillar 1 kind of solution, and we do have to recognize there is a value in the market, then maybe 12B should be seen as a codified, acceptable DST. And in the discussions on 12B, I even said to the UN Tax Committee, if you want to strengthen the arguments for 12B, you must add another provision to 12B that if two countries in a bilateral treaty have 12B, that they will not impose similar DSTs. Then you would have undercut the biggest problem of the US and a number of countries, that we have to do something about different types of DSTs. This whole argument got lost when the further discussion on Pillar 1 continued. And still today, when you read the OECD is hoisting the flag, because now we have the multilateral treaty on Pillar 1. But whether it will ever really be signed by all the countries or not, who then, when they sign, have to abolish their DST, which does not only apply to the 100 largest company in the world with a turnover of more than 20 billion, but the condition in Pillar 1 is that you have to delete, abolish your whole DST, also the DST levied from smaller companies. So the 12B discussion cannot be seen, in my view, completely separate from the discussion on. So 12B mentions software as a service, but even that is not clear enough, because if it is tailored software as a service, the UN would probably qualify it under 12A and not under 12B. So the fact that all these relations have not been clarified is simply because they have not really analyzed all these different kinds of matters. And so far, they didn't have to address the issue of software as a royalty because it doesn't exist yet in the model. So if it's put in, you will get the question of certain types of SaaS, IaaS, PaaS. Is that payment as a whole, is it a royalty? Because you get the right to use software. Is it something else in IaaS? Because you also get the right to use hardware? Or is it a combination of those plus Article 12A, if you have a platform kind of thing, which can also do tailored services? That is the reason why just deciding on one thing without looking at all these aspects, you are basically making a start with something without you really knowing, and without the taxpayers and the governments really knowing how it will apply in practice. And again, when all these withholding rates are the same, the problem is less. But when you have different rates for different categories, there will be a constant fight for taxpayers to try to put it under the for them most favorable rule, and for the government to put it under the for them most favorable rule, which is the highest withholding tax.
Lucas, Lucas was.
I just had a couple of quick comments about the last part of the lecture. Thank you very much, Professor, for the comments. I think one of them is back in 2021, my thesis was exactly about that. I proposed the creation of a database of approved precedents to be voted into and approved by the members of the inclusive framework by a majority vote. So those would be precedents from the local courts of the inclusive framework. And my idea was to have this database of approved precedents as a source for courts of the inclusive framework members to look into and potentially harmonize jurisprudence on the application of BEPS Section 6, which was the topic of my thesis, but it can be applied for other topics of international taxation and tax disputes as well. That's one way that you can perhaps loop courts in and invite them to contribute to the database so that they can feel represented as well, like the Indian Supreme Court, like the Brazilian Supreme Court, not only looking at the commentary from the OECD experts, but looking at something that has, I would say, more legitimacy for them because they are building it as well. They're part of the reason that this exists. So that would be my comment in terms of the sort of harmonization of disputes or prevention of conflict for the future. But I think that
respond to that.
Yeah.
I have the feeling that you were going to say something else as well.
I was going to say something else.
It's going to get lost.
Yeah.
First of all, just to pay credit to my own employer, it's the IBFD that created an international tax treaty case law database as the only publisher in the world with exactly that in, so that people could see what kind of case law there was on the interpretation of certain elements, which could be if it works, work as a kind of silent harmonization. The second thing which IBFD did to promote that is to create, not only in the past, co-founder of the European Association of Tax Law Professors, but also the IATG, the International Association of Tax Judges, which is now a vibrant organization which meets and has meetings to discuss these kind of topics with the idea of aligning it. The idea to come to an obligation on judiciary to harmonize matters is asking something which the EU has not been able to do in 60 years. There is only some kind of uniform interpretation by the European Court of Justice, but only on very specific EU law, which has been agreed unanimously by all the EU member states. So your thesis is very valuable as an academic product, but it may either never materialize or maybe only when we are 30, 40, 50 years further down the road, when in the end, there are so many problems in applying tax laws that people sit together and say, whether we like it or not, we have to do something about harmonization because the system is simply not running anymore.
Yes, my thesis was
Then we have some.
yeah, my thesis was not about mandatory harmonization. It was more a database that could be used as a source of interpretation by local judges to which they would be invited to participate. And also, I understand the point about silent harmonization. What I wanted to promote was vocal harmonization with the votes of representatives, especially for developing and underdeveloped countries. I wanted those votes to be part of the reason why certain precedents are there. And of course, there is the IATJ, which is very important for discussion of international tax disputes. I know that the members of our Supreme Court, for example, are not there. And if they are not there, the decisions that come from them may prevent Brazil from taking certain positions in the international arena because Brazil is constitutionally prohibited from doing so. That's just the point. It's not mandatory.
ATG does not give recommendations or doesn't say how to do. It only shares information.
Sure.
And one thing I just want to mention about that too, what is very dangerous with comparing case law is that lots of case law, and certainly in the kind of areas we are discussing, is not only principle-based and legal theory, but is many times extraordinarily dependent on the specific facts and circumstances.
Yeah.
So it's very difficult to reach a more even a vote on matters, because you will have to spell out all the details of the facts and the circumstance, because if there is a tiny bit different, there may be a different solution.
Sure.
But I think we are not discussing your promotion PhD, which if I would have been in the commission, I might have put all kinds of questions and arguments.
Yeah, the other point was just when you mentioned enabling software, I was thinking of enabling copyright. That could be a difference between the books and perhaps software that we import. Perhaps just putting that to you as a comment. There's, in my mind at least, there's a clear difference between paying for copyright that I consume and paying for copyright that enables me to do things. So if I pay for example, I could pay for copyright from a video game, and in the video game, I could actually, there are certain games in which you can produce things in the game and sell them for real money. But this is just me this is just me playing the game. I'm not actually, I don't have the source code or anything. I'm just a consumer of that product. But that would be sort of a differentiation that I would make between the two. One of them is just for my own consumption. I can do nothing with it. Perhaps I can replicate its ideas or talk about its ideas or write a book about the book. But the other one is it enables me to do things with just using the program as a regular user.
The problem with the enabling, because otherwise we get a confusion, of course, when you buy a book, it also enables you. I mean, if it is only a book to read about the romance between, well, I would say almost ridiculous romance between things, because I am not a very romantic person, so I would never spend money on this kind of product. But I mean, I can also buy a book which learns me how to maintain my garden, which is very important because that's one of my tasks at home. There are even books which I absolutely don't want to receive. These are for my wife. Do it yourself in the house. I don't want to have those books. I don't want to read them. So also already in books, there are, of course, an enabling. You are not allowed to multiply and exploit the copyright in it. But if you are buying a book, but you cannot use the content of a book to develop your further ideas, etc., you would never buy a book because you could do nothing with it. So there is an analogy with enabling. The point is, however, that here, in the case of enabling software, you get something which enables, for which you don't pay a price. When you pay for real software which can operate things, you're paying a price for it. When you pay a book, you're paying a price for it. I don't know an enabling book which I get for free. I don't know, I cannot compare with enabling software. I don't see the analogy. But that's just not to confuse, but to try to clarify the discussion, which is very interesting.
No.
Just a brief comment, Professor. When you were mentioning SaaS, I thought that Article 12B, if I'm not mistaken, there was a minority within the committee that said that Article 12B should not apply to B2C transactions. So automated digital service provided for individuals should not be object of Article 12B. However, the final version of the article applies to B2C.
Yeah.
And I was thinking, is this the same minority view of the red part that you put on the slides, applying royalties provision to use of software? Because there is no overlap. If Article 12B does not apply to B2C according to this minority view, which was not the final version of Article 12B, then it makes sense to apply Article 12 royalties to the use of software as I'm using right now in the computer, example.
What is the common element in that discussion of those articles is the size of the source taxing right you want to have. And of course, if you want to optimize the source taxation, you want to cover everything, including B2C. If you are of the opinion that this should actually not be the case at all, but you have to swallow it for one reason or the other, you try to limit it. And then you go to only business to business. Now, as I mentioned, it is not only a matter of the amount of source taxing right, but there is also the operational implementation of it. And generally speaking, creating withholding obligations on individuals is in practice extraordinarily difficult and can only be achieved via a detour by putting these burdens on banks or putting them on the foreign provider, like in the VAT system.
There is a very minor observation. The article of the commentaries on the collection mechanisms.
I know.
The B2C but I feel that another comment that there is another overlap with regards to gross taxation and net taxation, because Article B works with gross taxation as Article 12 of the UN model. But Article B also provides an option for net taxation.
Yes.
So you mentioned the possible overlap within Article 12 by applying different rates to each type of royalty. But there's also a possible tax planning opportunity or tax planning door to use Article 12B because it provides a net taxation. It can be sometimes or most of the time.
Did you ever try to apply that rule?
It's a very difficult.
It's an
article to read.
extraordinary complex rule, which is not very detailed defined. It speaks about profitability ratios without exactly defining what they are. When you read the commentaries, it turns out they are talking about commercial accounting and not about tax accounting. You know what happened in Pillar 1 and 2. If you, as tax lawyers, cannot solve a problem, you throw it over the fence to economists and you say, no, but they know how to do it with general accounting standards. I'm an economist. I can tell you there is a lot of diversity within accounting standards and different views. So yes, why did they have the net option in 12B? Because a lot of countries were in doubt whether to allow 12B at all. So in order to get a majority within the UN Tax Committee, they tried to remedy the idea that 12B might be excessive as taxation on gross, and they created the net. But the problem with digital economy is to determine the net. What you are basically asking when you want to give a taxing right to the market state without physical presence is what is the price of the market? And nobody knows. So that's why Pillar 1 speaks about 20 billion euro, speaks about only a redistribution of 25% of the excess revenue over 10%. On what is these figures based? Then you look at 12B. 12B allocates as a deemed determination of the net income, the profitability of the provider in that segment. If the provider does not keep books of that segment, it is the profitability of all the activities of the provider, which is already special. If, however, the provider is part of a related multinational, then it's the ratios of profitability for the group as a whole in its segment. When it doesn't keep the segment, it's the profitability of the group as a whole. That is, in a nutshell, the approach of the net taxation. Why is it there? Is it there for tax planning? No, because the person who put it in is the one that tries to kill tax planning everywhere where possible. It is to take into account that a number of the IT companies are for many years loss-making. Many of the even car producer like Tesla, for 10, 15 years, they were loss-making. And that is the problem with gross taxation. If there is a payment for a service to a loss-making company, you still have a gross taxation via the withholding on the gross income. So that net income exception was not made for tax planning, but to make it digestible and to at least give an option, although very difficult to determine this deemed net income, which cannot be determined by traditional transfer pricing, to take out the companies that can prove they are loss-making. They opt for this difficult net one, and the ones which have a profit margin which is less than the rate on the gross income. The UN model, like in the other articles of withholding taxes, does not define the level of the withholding tax. So you cannot even judge what it means in practice if you don't know how high the real withholding tax will be. If it will be 10%, there will be more companies trying to opt for the net one than if it is 1 or 2%. So there is a net option. But the problem is everybody realizes that creating a net option for all these circumstances is very laborious. We have the whole system of withholding tax to avoid, in the case of a non-resident, to always have to determine the net income. You know the problems of determining the net income of a PE. We discussed it yesterday during the lectures on the UN model. The UN still sticks to only a part application of the separate entity approach with many exceptions. And the OECD has advanced to the authorized OECD approach, but which is much more laborious and more difficult to apply because you must apply the transfer pricing methodology on a fairy tale. So I make sometimes the comparison when you are a parent and you have a small kid, you need to tell a story to the child before it goes to sleep. So then you can test your own imagination and you are telling, you know, a story like this. The next day, you have to tell your small son or your small daughter, say, can you continue that story about the rabbit? And you don't know all the details, so you will expand on that story and the child very impressed. And the third day, again, you've been working hard all day, you don't remember everything, and you have to continue the talk, and you say, yeah, and the rabbit is doing, and then the child says, but yesterday the rabbit was dead. How can it still do things now? So, and this is my analogy with transfer pricing. Transfer pricing is on real legal transactions, and you compare with a fictitious situation as if it were independent. When you talk about determination of profits of a PE, there are not even transactions because it is something between the head office and the PE. So it's one big fairy tale. The first element, you deem a transaction which doesn't exist. And on the deemed transaction, you are determining a deemed price. And that's what I mean. You must be cautious not to get stuck in your own story in the end. Okay, it was a bit of a deviation. Okay, what shall we do with the drunken sailor? We will just ruthlessly continue until the very end, 10:30.
No, I think this is this. Yeah.
What I can do is summarize in 5 minutes where we have gone now.
I think that's
Shall we do that
yeah,
and then
yeah.
stop it?
Sure, yeah, because I guess the
Otherwise-
building has some restrictions when it
Otherwise,
comes to
tomorrow
10:30.
everybody is with, you know, like this because nobody slept. And I even have jet lags, huh?
Sure.
I'm sitting here
sure,
fresh
sure.
as if there is no time differences. I simply ignore that. Huh? So to continue the story very briefly, this was rejected. We have the 2021 same text with minority view and this recommendation of a text which has no commentary. Then last year, there was an intermediate document because it was decided by the UN Tax Committee to continue the work on this, to try to solve those problems which we have seen. So last year, there was an ultimate attempt of the source-based taxation people to say, we still have a proposal that we can interpret the existing text to cover the cases 4, 5, and maybe 6. Of course, that was deemed doomed to fail. I also raised my voice against it, because if you want to create total confusion, you must suddenly make a 180-degree change on the interpretation of a text which has not changed. So that was rejected last year. They continued to work, but in the end, I think the whole committee wanted to get rid of the problem because you cannot keep going on. So what they did in 2023 now, so just a month ago, there was this paper for the UN Tax Committee, which had a beautiful reformulation of the commentaries. I can only compliment them. They have much better structured the commentaries, but basically the text with some small editorial things, the text is still the same as the 12.3, which we have extensively discussed. What is the end of the story? Because of its composition, 15 developing countries, 10 developed countries, by majority, the UN decided to adopt this 12.3, explicitly stating payments for the use of software are royalties, basically keeping the same problems which we were discussing, but putting carve-out options in the commentaries. Partly they were there already in 2021, so they have now put in a carve-out option to exclude from the scope payments made by individuals for private use. So there is now a legal text to secure that. There is another carve-out for embedded software. Any kind of combined payment where there is no separate payment for the software will not be treated as a mixed contract where you try to disentangle. So what is my overall conclusion? We have the kind of 12.3, which we have extensively discussed, where we still have a lot of debates, where we still don't have full clarity of the interaction of all these phenomena, 12, 12a, 12b, but there are a number of carve-outs. So what is my experience as treaty negotiator say? A victory for those who wanted to have it in the model, but will they ever get it in practice, will be a matter of negotiation. And if it is an OECD country that is facing negotiation with a developing country, and the OECD country is the most important one if you want to get money, because that's where the suppliers of the software are. They are not in the poor developing country. So if you really want to make more money, you need to convince the OECD country that is completely opposed against it. So they will either completely refuse to accept 12.3 in the amended form, which they can do with the largest part of developing country, because they have no power, so it will not be an equal match. And with the more powerful source country, they will try to get a number of those carve-outs in order to mitigate the effect of this very broad source taxing right. That is a little bit how I assess the situation. So we have not further clarified a number of problems which are there, the inconsistency with books and things, the exact analysis of modern forms of SaaS, IaaS, PaaS. We have left that for the future to further discuss that, but there is now a very broad provision in the next update of the UN model, with also many carve-outs. So what will in the end be in 3D practice will depend on the bargaining powers and the economic position of the countries. I think we are maybe done.
Yes, and
I need a big pint of beer now. My throat.
I was happy to hear that you will be here for the next 30 or 40 years to see the outcome of that. And for those of you who are interested in the article's name written by Jan de Huda is similar to the name of this class. It's called "The Future of the Taxation of Software Payments reflections on the proposal to amend Article 12 of the UN model as discussed by the UN Tax Committee in April 2021. It was published in the Bulletin of International Taxation in 2021. It's very sophisticated, detailed. It contains much more information than the ones that we discussed today. Jan, I must thank you again and thank IBFD for allowing you to come here and spend some time with us, sharing your knowledge. IBFD and IBDT have a long, fruitful partnership, and we hope to keep it working for the next years. And I also failed to mention, but I'll do that in this last minute, that Jan is one of the most awarded persons I know. He, the greatest thing I can say about him is that
connection
is that he's a very nice person, but he's also a knight with a K, like a knight, recognized as a knight by 2 countries, and that's why he's holding that specific thing on his suit. So he is recognized as a knight by the Republic of Poland and also by the Kingdom of Netherlands. It is a great honor to have you here. And now you can picture him as someone who rides a horse and, fights. But that's not exactly how it goes, right? Yeah. Thank you very much.
I think I should receive an exception when I enter into a plane that I can carry a sword. But that makes it real. And just to avoid one misunderstanding, I did not get those awards for tax work. So in those countries and in many countries, there are inventors that do very special invention. They can get that. You can also get such a distinction if you regularly win Formula One races. I hardly dare to say that here now because of the recent one in Sao Paulo, but in my country and also in Poland, to get things like that, that is usually also because of non-paid charitable activities. Just doing your work properly generally is rewarded by a salary. Some people have a moderate salary, other very high, but then it's well rewarded. So that's just to make that a little bit more, everybody can do that. Huh? You just need to spend the time on. Okay, it was a very great pleasure to be here. And with the students, we continue tomorrow with another issue where people could easily get lost, and that is triangular cases. Okay. Have a good night.